right, good morning, everyone. Thank you for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So, whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar today. Second, we will be sending you a visa guide covering the visa types that will be introduced in this webinar today. And the guide is a comprehensive guide that you could use as a resource. We will also send you a link that you can follow to sign up for additional webinars that are coming up in the future. And also, we will send you a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we regularly upload a variety of immigration-related videos that will be helpful to you. Finally, we'll send you a link that you can follow to set up a consultation with any of our experienced attorneys should you wish to discuss your case in further detail. Today, we're very lucky to have Kelly Weiner, who is a partner of the firm, who has a wealth of experience handling cases in the visa categories that we'll be speaking about today, who will be presenting about these various options available for extraordinary ability individuals and the requirements and considerations. And I will also be your panelist. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started.
Thank you, GA. So we're going to get started just moving to the next slide. And we're going to talk a little bit about the extraordinary ability visa categories, initially focusing on the temporary visas that are available for people with extraordinary ability. So there's the O-1A visa. This is a non-immigrant, meaning a temporary visa for people with extraordinary ability in the sciences, education, business, or athletics. The standard is quite high. You have to show that you are one of the small percentage who have risen to the very top of your particular field. Then we have the O-1B visa. This is a non-immigrant temporary visa for individuals with extraordinary ability in the arts or in the motion picture or television industry. And there's a slight difference in the standards for these. The standard for the arts means the person must have distinction in their field. This is kind of defined as a high level of achievement. Shown by a degree of skill and recognition substantially above that ordinarily encountered. So it is a lower standard than the O-1A, but still, need to show this, high level of achievement. And then standard for motion picture and television industry, which is higher than for the arts. You have to show you've reached a level of acclaim substantially above that of your peers. You can go to the next slide. So these are the green card, so kind of permanent options for people with extraordinary ability. The most commonly known one is the EB-1A green card. So this is for individuals with extraordinary ability in the sciences, arts, education, business, or athletics. So for the O-1A and O-1B, they separate out arts from these other categories. For the EB-1A, there's no separation. There's one green card that's available for people with extraordinary ability. And you have to show that you are one of the small percentage who've risen to the very top of your field, shown sustained national or international acclaim, and your achievements have been recognized, and you're coming to the US to work in your area of expertise. So that's an important point. This is not kind of for people to come and retire in the United States. You do have to include a statement showing that you do plan to work in your area of extraordinary ability. Also important to know that because the standard for this is higher than maybe the O-1B distinction standard or motion picture and television standard, if you are going from an O-1B distinction standard and trying to apply for an EB-1A, there's, perhaps a gap, qualifying for that. That's just to say that just because you qualify for an O-1B or even an O-1A, it's not an automatic that you will be granted an EB-1A. Because this is something that allows you to, live and work in the United States permanently and eventually apply for U.S. citizenship. To get the EB-1A, the standard is much higher than it would be for the O-1B and even for the O-1A. So, this is something where if you do have that goal to eventually live here permanently, you can try to plan with your attorney as you put the O petition together. It may be something where if they don't feel you have a very strong case, or maybe you got your O-1 only after a very difficult request for evidence, perhaps you work on your profile. You use that time in your O-1A to accomplish even more in your field to show that you really do have that extraordinary ability, and then ultimately apply for the EB-1A in the future when you have a stronger case for that. We've also mentioned here the EB-2 National Interest Waiver. Now, this is not always considered or lumped in with the extraordinary ability visa categories in the same way, but we mention it here because it is a really good option for people who, are extraordinary in their field, but maybe haven't quite reached, the level of EB-1A, but are working on projects that are extremely important to the United States national interest. And so this can be a good option to consider for scientists, researchers, entrepreneurs, leaders in their field who are working on endeavors that have substantial merit and national importance to the United States, who are well positioned to advance that endeavor. And then on balance, the argument is that you should waive the normal PERM process labor certification that requires a U.S. employer, that requires a labor market test that can be quite onerous to get through. The argument is that you should waive that because the person is working on something that has this substantial merit and national importance to the US, and they're well positioned to advance that endeavor. So generally, if you are somebody who is working in a really important field, making, large advances in that field, but perhaps because of the way academia works or because of the way your industry works, you wouldn't quite meet that EB-1A standard. The national interest waiver can be a good one to consider because sometimes the importance of what you're working on can help carry that petition through. It is important to note it's EB-2, not EB-1. So there are worldwide backlogs in availability of green cards. Kind of worldwide, it's maybe a year, a couple of years. There are longer backlogs for people from India and China as well. So we can move to the next slide. All right, let's turn back to the temporary, O-1 visa, the O-1A in particular, what you need to demonstrate. So to qualify for this visa, you have to show that you have received either one major internationally recognized award, such as a Nobel Prize, or much more commonly, people are applying by showing they meet at least three of the following criteria. These are things like receipt of nationally or internationally recognized prizes or awards, membership in associations in your field which require outstanding achievements of their members, publish material in professional or major trade publications about you and your work, original contributions of major significance in your field, authorship of scholarly articles in professional journals or major media, a high salary, in relation to others in your field, participation on a panel or individually as a judge of the work of others, employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. Sometimes when people are looking at an O-1A, they really tend to just focus on one part. So, I've been employed as a CEO. Great. Now you have to look at for an organization or establishment that has a distinguished reputation. So if you, opened your own company and you were the CEO, arguably you had a critical essential position for that company, but perhaps your company, if it was just a one-man shop and was very small, would not meet that criteria of organization or establishment with a distinguished reputation. Similarly, membership in an association in your field. For example, anyone who's passed the bar who's a US lawyer can usually become a member of a local bar association by paying a fee. That's not going to be a good piece of evidence for the O-1A. You have to show that it's a membership in an association in your field that requires outstanding achievements of its members. You have to look at what are the criteria to get in. Can just anybody who has the basic professional credentials get in? If so, it's not going to be a good piece of evidence for the O-1A. Similarly with awards, Are they nationally or internationally recognized? If these are kind of student awards that are only given to students, that's not going to be a good piece of evidence. If while you were a student, you participated in a competition in which, other professionals in the field who are not students also participated, and it's nationally or internationally recognized, and you won while you were a student, that's something that could, potentially work. So you do really have to look at the criteria, think what actually meets the criteria? And then also kind of does this give the overarching impression that I'm somebody of extraordinary ability in my field? And so it's not always just about throwing every piece of paper, everything award you've ever gotten in your whole career. It's about being strategic about what you're including, to show that you meet the criteria and, also that you're someone of extraordinary ability. All right, turning to the O-1B. So the structure here is very similar, but it's focused on arts because that's the O-1B is for the arts. So you either are nominated or received a significant national or international award, like an Emmy, a Grammy, or you have evidence of at least three of the following. And as you can see here, I won't read them all, but they are all kind of focused on, things that would be relevant for people in the arts. Some of them, if we go to the next page, are a bit dated, cassette and compact discs or video sales. So, for some of these, like other comparable evidence can potentially be used if this is kind of a really new field. So, sometimes people are getting O-1Bs as kind of social media influencers. There may be different metrics that they are using. And it is really important for the O-1A or O-1B to really define your field. Like, what is your niche? There are some people out there who have very particular niches. Someone got an O-1 for being a water sommelier. That was a pretty interesting, not a case that we did, but a case that's out there. But you really do want to define your field. Sometimes, there's a question between O-1A or O-1B. O-1B may be better if it's, a more borderline case because O-1A does have this higher standard. And again, like if it is the type of thing where maybe other comparable evidence can be used, you can try for that. It is quite difficult because you have to show that the other categories don't apply for your particular type of industry. That being said, if you do have a very, niche industry, there's been kind of tattoo artists working in certain areas, mixologists. If there is an argument to be made, you can make that argument, but you would need to show here's why it doesn't actually, here's why I need to use other comparable evidence because it doesn't apply to my particular field. All right, let's talk about the differences between the O-1A and O-1B. So we've already kind of mentioned O-1A is for science, education, business, and athletics. O-1B is for arts or motion picture or television. The standards are slightly different. O-1A is a higher standard, a small percentage who's risen to the top of their field, as opposed to arts, high level of achievement and distinction, or motion picture, level of acclaim substantially above that of your peers. For issuance, you can initially get an O-1 for 3 years, and then you can extend it in increments of 1 year if you're just finishing out the same project. If it's a new employer, new set of projects, new itinerary, you can often make an argument for another 3-year approval. Your family can come to the US. Your spouse and any unmarried children under 21 can come with you. They can study in the US, go to school. They cannot work, neither your spouse, nor your children. All right, let's talk a little bit about the EB-1A. So it's a very similar, set of requirements to the O-1A and O-1B. It just kind of, slightly different because it combines the arts with science, education, business, and athletics. There's not kind of a separate green card category. So it's, similar in the sense that, one very large award or at least three of the following, which are, listed here. As I mentioned, it is harder to get an EB-1A than it is to get an O-1A or an O-1B. You're asking, as opposed to asking for a temporary, 3-year visa, or sometimes even less if, you have art projects for only 6 months. Maybe you're only asking for 6 months. An EB-1A does allow you to live and work in the U.S. permanently. So it is something where they'll be looking very closely to see if you meet the criteria. And again, if you had a very hard one O-1A, you had a really difficult request for evidence, you really want to use that time on your temporary visa to build up your profile and add more to put yourself in the best position for an EB-1A. The EB-1A can be something sometimes that you work towards. There's sometimes people that come to us and say, well, like I usually turn down interviews or requests for publications. I'm just busy. Sometimes, it's good to look at these criteria and say, maybe I should say yes to more of those invitations when I'm asked to speak, at universities or give keynote speeches if I'm asked to publish something. These are all things that help build up your profile in a way that, can be very helpful for this type of green card. Okay, so we're going to talk here about kind of the normal process that they use to adjudicate EB-1As and O-1A and O-1B, while also noting that there was a major change, less than a month ago that could really change the landscape and how things look moving forward. Kind of historically, like what, had been happening kind of before January 28th, 2026, there was this adoption of this Kazarian test by USCIS, where they said essentially, we will look to see, do you meet the plain, kind of requirements, the plain language of the requirements? Do you meet at least 3 of the criteria to show that you have extraordinary ability? But that's not going to be enough. After we assess, okay, you've met, at least 3, we're going to then make an assessment based on the totality of the circumstances, the quality of the evidence to determine if, based on a subjective analysis, the officer thinks you are someone who's risen to the very top of your field. And this is kind of what they currently use to assess, whether you meet the criteria. So unfortunately, even if they found, well, we think you meet 4 of the criteria, but when we look at it holistically, we don't think you're someone who's risen to the very top of the field. Therefore, you can be denied. A major change to this happened on January 28th, 2026, when a federal district court in Nebraska ruled that USCIS's adoption of this test was unlawful because it's something where normally if they want to adopt something like this, they have to follow, the Administrative Procedure Act. They have to go through notice and comment rulemaking. There has to be kind of regulatory guidance. None of that was done. This was all adopted kind of through memos as an internal policy position. And this judge in Nebraska has said that was unlawful. This is not binding yet. It's not binding across the country, only, in the jurisdiction where the judge made this ruling. But it is very persuasive authority. And, we are hopeful that it will cause kind of a reexamination of how they're going to do these adjudications, because it is very likely that in other jurisdictions, many other people will be making similar arguments. And especially because of kind of changes in kind of court cases, in particular, the overruling of Chevron, which has led to less deference being given to agencies such as USCIS when they make decisions that are not in line with kind of what the actual regulations say. So this actually is something where it's having kind of a good result, for people who are applying for the EB-1A. And the O extraordinary ability visas, because it's, possible that Kazarian and this 2-step test, which involves this really subjective analysis by an officer of what they think, based on the evidence, may be on its way out. So that was some very positive news, for extraordinary ability applicants earlier this year.
All right. Thank you, Kelly. Thank you very much for the insights. And now I guess I'll shift gears a little bit now and let's go through the NIW, which is another green card option. And it is also a self-petition option that can be used for certain clients who may also be exploring the extraordinary ability options, because there can be some overlap in the types of profiles that can qualify. So let's go through the requirements here. So what are the NIW green card requirements? Now, for all cases in the EB2 category, you do need to show that you meet the threshold requirement. And you meet the threshold requirement by showing either of the 2 things. So you can show that you have an advanced degree, which is defined as a master's degree or higher, or the equivalent of an advanced degree, which is defined as a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the profession. Now, let's unpack that a little bit. So, if you have a bachelor's degree in engineering, for example, the post-baccalaureate progressive work experience must also be in that same field. And also, it must follow your degree. And what do we mean when we say the work experience must be progressive? In such cases, you would need to prove through detailed letters from your previous employers that not only did you work full time for the required 5 years, but that your job duties and your responsibilities changed in complexity, increased in complexity, and the level of duties over time. So if you were working in the same, position for 5 years and only doing the same types of duties for the 5 years, such that everything was static, then it may not be enough to show that you have the equivalent of a master's degree because you need to show progressive work experience that changed, increased in complexity over time. Now, if you don't have a master's degree or higher, if you don't have a bachelor's degree, or if you don't have the required work experience to prove the equivalent, there's another way you could qualify under the EB-2 threshold, and which is by showing that you have exceptional ability in the sciences, arts, or business. And it is interesting to note that exceptional ability is defined as a lower standard than extraordinary ability. So you do not need to show that you are one of the small percentage that have risen to the top of the field. You only need to show that the evidence tends to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the field. So, uh, assuming that the evidence in totality would show that, you also need to show that you have evidence under at least three out of the seven criteria that is listed here. So, for example, any academic record showing that you have a degree, diploma, certificate, or a similar award in your field doesn't need to be a bachelor's degree. If you have letters that can document at least 10 years of full-time experience in your occupation, for example, that can also be part of the evidence, a license, or record that you have commanded a high salary in relation to others, membership in a professional association. Now, if you look at the criteria here, you can recognize that the language is a little bit different from the criteria that's required under the extraordinary ability channels. So, for example, when we speak of membership in the exceptional ability uh, inquiry, we're looking for just membership in a professional association, as opposed to the EB-1A, criteria which required memberships in a professional association that required extraordinary ability of its members. So there are definitely a lower things that you need to meet when you're looking at exceptional ability as opposed to extraordinary ability. Similarly, you can provide evidence that you've been recognized for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations. Other comparable evidence can also be acceptable. So you do need to show at least three out of the seven that is listed here. And those evidences must tend to show that you are someone who has a degree of expertise that is significantly above what is ordinarily encountered in the field. What is important, though, is that either your degree or your exceptional ability, they must relate directly to the proposed endeavor that you are coming in to do in the United States. And we'll talk a little bit more about what proposed endeavor means. All right, so now that you've proven that you meet the EB-2 threshold, the other challenge is to demonstrate that you qualify for a national interest waiver. And this part is very important because if you show that you qualify for an NIW, you are exempt from the ordinary labor certification requirement that is imposed on employment-based petitions, most employment-based petitions. So that is what we're asking for, a waiver from that requirement. And this is the reason why national interest waiver applicants can actually self-petition for the green card, as opposed to requiring a U.S. Company to sponsor them and go through what can be a very time-consuming and complex process of getting a labor certification, testing the U.S. labor market, showing that there is no other U.S. Worker who is able and willing to take that particular job. But if you can prove these three-prong Dennis-R factors, then you are able to move forward as a self-petition, even if you don't have a U.S. job offer. So let's go through the three-prong matter of Danaher test. How can you qualify that you are eligible for a green card under the NIW program? So the first prong is to prove that your proposed endeavor has both substantial merit and national importance. So the proposed endeavor is what the applicant is coming to the United States to do. And it should be more than just a plan to work in a particular occupation. So for example, if you just say, I am an AI engineer and I would like to find a job in the US, unfortunately, that in itself will not qualify as a proposed endeavor. The government is looking for a more specific and concrete plan about what you will be doing within that occupation. So for example, I'm an AI engineer. I am developing a particular solution that will, for financial institutions that will increase efficiency of a particular, process that people go through with auditing that will make it 80% more efficient than existing, methodologies. So that kind of specificity, right, is what the government is looking for when they speak of a proposed endeavor. Now, you need to be able to prove that the proposed endeavor has both substantial merit and national importance. And let's talk a little bit about what that can mean. So, endeavors that tend to further human knowledge in key areas such as business, health, education, science, technology, and some examples in the matter of Dennis, our case law includes medical advances or improvement in engineering, manufacturing processes. Those types of advancements tend to further human knowledge, tend to further the best practices of a field as a whole, as opposed to just generating a private profit for oneself or one's immediate employer. So endeavors that have a broad impact are favored in this first prong. Another way to prove substantial merit and national importance is by a very strong and broad economic impact to the field, to the nation, or to the region in a broad way that goes beyond just benefiting your immediate employer or your immediate clients. So really the important question to ask regarding a proposed endeavor is what is the future impact that is expected and how can that be important to the United States as a whole? And it does not need to geographically touch every single state, but definitely there must be a broad enough impact that can convince the government that the benefit goes beyond just one company or just one company's immediate clients. The broader the impact would be better. Endeavors that advance, key technologies in a broad way, such that, not only your company would benefit from it, but maybe other companies are going to be licensing this technology, which if it is an innovation and if it can result in a field-wide advancement of best practices, those types of endeavors can really have a compelling edge for substantial merit and national importance. So data that can support substantial merit and national importance include expert letters, very targeted expert letters. And if you can get an expert letter from a government agency that covers the field, discussing your very specific proposed endeavor and confirming why that will, advance policy priorities. Government expert letters can be very helpful in proving substantial merit and national importance. Government pronouncements and declarations can be helpful, but if it should ideally be supplemented by those very targeted expert letters from U.S. partners, U.S. agencies, U.S. institutions in the field that are interested in your endeavor, talking directly about why the impact will be large, and how systemically, your project will result in advancements, as opposed to just benefiting a single, company or the company's immediate clients. Other data showing importance. So, for example, if you're an entrepreneur, for example, and if you're developing a startup. And if you want to, make the argument that your startup will have a substantial economic benefit to the region and to the nation as a whole, you can provide economic projections, right? A letter from an economist, for example, quantifying the projected economic benefit on the region, the quantum of job creation, and things like that. That type of data can also show the importance and prospective impact of your endeavor and how it can go beyond just benefiting your immediate private interest. The second prong of the matter of Danisar test is that the individual must be well positioned to advance the proposed endeavor. And here, the focus is on the individual as opposed to the focus being on the prospective impact of the project itself. So the government will look at the applicant's education and experience. The government will look at the applicant's track record in similar projects that they have led in the past and the impact of those previous projects on the field. So if you can provide a portfolio, for example, of those previous projects, maybe some of these projects were discussed in industry media, and maybe you can get other experts to speak about why those particular projects were particularly successful and served as a role model in the industry. Those types of evidence can be very helpful in painting a picture that you are someone who does have that track record of success in similar pursuits. Intellectual property can also be helpful in terms of showcasing your impact. So, for example, if you authored journal articles uh, on a particular technology that you're an expert in, if you have been invited to speak at conferences, if you authored patents, if you're the inventor of a particular technology that has been patented, and if you can show that that particular patent has been licensed and commercialized by other companies, those types of evidences really show that your work has had an impact in the field that is broad. So those types of evidences can be very helpful in meeting the second prong. Advancements towards the endeavor can also be helpful on meeting the second prong, especially if you're an entrepreneur and if you have made progress on developing your project to date. So, for example, if your business idea has been accepted for a prestigious incubator or accelerator, if you have secured investment from venture capital firms, showing, that maybe, third parties are recognizing the industry disruptive potential of your project. That can be very helpful in showing that you're well positioned to advance the endeavor to a successful result because you have already built up that traction within the industry, built up that traction in the United States. So interest by potential business partners, interest by potential clients. And if you already have contracts with your business project, with major US corporations, major US investors, those types of concrete evidences can show that there is really more teeth to your business plan than just being a plan on paper. So if you can show that you've made sufficient progress, that can be very helpful. For meeting the second prong, that you're well positioned to advance the endeavor. Finally, the third prong requirement is that on balance, there must be a showing that it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification for your particular case. So here it is really like a balancing test. So there are a couple of strategies you can use. You can rely on some of the arguments you made for prong one. If your work will have broad systemic benefits to the field as a whole, that can outweigh the ordinary benefits of protecting the US labor supply because the benefits of your particular case will be so large. You can also rely on some of the evidence you use for prong two. If you have unique know-how and experience that cannot easily be replaced, that other US workers with minimum qualifications may not have, that in itself can also be a factor towards, pointing towards granting this waiver to you, just because the traditional labor certification won't really produce the same results. Some special considerations for entrepreneurs, for example, if you can show that your work will have a substantial economic benefit to the United States, such as a high number of US job creation and high generation of tax revenues, that can be a significant countervailing benefit to, the ordinary benefits of a labor certification, because one of the motivations for Congress having this labor certification system is to protect the US labor supply. But if your business will be adding a high number of jobs to the region, then that in itself is, something that already advances Congress's intent. So that can be a very strong factor towards meeting the third prong. All right. So now let's shift gears a little bit and talk about expert opinion letters, which is a key aspect of all of the visa types that we will be talking about today. So expert letters are relevant for O-1, EB-1A, and NIW petitions. The purpose depends on the type of case that you're using and the type of prong that you're trying to prove in with regards to eligibility. But generally, for the EB-1A O-1 visa purposes, you would want the experts to confirm generally that you have extraordinary ability in the field and is well known, and that your achievements have been outstanding in the field. So really, those letters would be looking at the past, your previous achievements, and how they have been impactful for the field. Now, with regards to the NIW, the function of the letters can be a little different. So if you want the letters to support national importance, those letters will be future looking. So those letters would have experts comment on the future impact, the expected impact of your proposed endeavor, and how that would rise to the level of national importance. Now, even in NIW context, some of the letters can talk about your previous achievements. So, for example, if you're using experts to bolster your well-positioned argument, that you're well-positioned to advance the endeavor, those experts can talk about your previous achievements, previous projects, and how and why your achievements were significant for the field. So who is writing the letter? Who is writing a letter is an important aspect to consider. You don't want just your peers or just people who are more junior than you to write a letter. You would want leading experts in the field to write a letter who typically have decades of experience. We would typically include the full curriculum vitae of the expert. That really shows the USCIS why we would want to trust the assessments of that particular expert. So the credentials of the expert is very important, especially for O-1, EB-1 petitions. You want to get letters from leaders in your industry with a very prominent profile. If you're a business person, you want to get letters from senior people who are holding senior positions in leading institutions. With regards to the NIW, especially if you're trying to support the national importance prong, if you can get a letter from a representative in a government agency, a U.S. government agency, that can be very, very favorable for your file. Um, how does the individual know you? That is also another important consideration. Usually, we would want to have a mix of independent letters and inner circle expert letters. And when I speak of independent experts, those are people who haven't directly worked with you, but know you through your work or through your reputation in the industry, and who can confirm more objectively that your abilities are outstanding in the field, or that your work stands to impact the field if you're using them as a NIW national importance support letter. By contrast, inner circle experts are people you have worked with in the past directly, and those who can speak directly to your previous projects or previous achievements in the past. And those letters are also valuable because they provide a more direct testimony about what you have done for a particular organization, for example, and why that was impactful. For example, if you're preparing an O-1 case and if you're trying to argue that you've played a critical role for a distinguished organization, it is very helpful to get an expert letter directly from someone who worked with you before in that particular distinguished organization, who can provide this direct personal testimony about what you have done for this organization and why those contributions were of significant importance for that organization. So now for the final point, let's talk about the content of what needs to be discussed in those letters. Now, the thing to note is that specificity and concrete detail is very important in this procedure. Letters that are formulaic and letters that simply repeat the regulatory language are definitely not effective. For example, you don't want the letters to just say, oh, the applicant is a well-known figure. You want the letters to go beyond that and provide the concrete detail. Why is the applicant well known? How is the applicant well known? What are some of the recognitions, forms of recognition that show that the applicant is well known? And what is the applicant well known for? What did the applicant to do that is simply so superior and so different from how things are normally done in that field? Similarly, the letters cannot just say conclusively that the project has national importance. The letter must go beyond that. The letter must describe, very specifically what the project is trying to do. What is the limitation in the field that is, causing a problem for the nation? How is this project going to alleviate this problem? In what way? Who will stand to benefit from it? What will be the scale of the benefit? How many people will this impact? What is the quantum of economic, revenue generation or job creation? How many jobs? Those specific details are what we're looking for when we speak of persuasive expert letters. And expert letters that don't go there, expert letters that just stay on the very general statements, unfortunately, that will not have a lot of evidentiary strength for USCIS and can lead to not optimal results. So definitely the important point here is to include as much specific detail as possible and as helpful for your case. All right, now let's talk a little bit about the strategic considerations that come in when we are deciding which category you should apply for, depending on your circumstances. So the first question to ask is, do you want to stay in the United States temporarily or permanently? As Kelly mentioned in the previous slides, the O-1 are non-immigrant visas. They are temporary, well suited for people whose intent to work in the United States is temporary. Now, the EB-1A and NIW are both green card categories, and they are well suited for people who want to live and work in the United States permanently. Now, it is important to note that although the O-1 and O-1, O-1A, O-1B are non-immigrant visas, there is no lifetime limit on how long you can stay on an O-1 visa. So it is possible that you can continue to renew the O-1 if your plan is to come to the United States, explore opportunities, and maybe change to a more permanent option at a later time. So there can be some time that you have to work on your profile. The second question is, do you have a U.S. employer or agent, or do you want to self-petition? So for the O-1 visa category, it is a requirement that you have either a U.S. employer or a U.S. agent. And when we speak of a U.S. employer or U.S. agent, it is also a good idea to keep in mind that for entrepreneurs, it is possible for the entrepreneur to create a U.S. company, a U.S. corporate entity in the United States, and that can be considered a separate legal entity from the person who made the company. So you can use your own company to petition for the O-1 visa. But in that circumstance, it is also very important to have sufficient evidence that there is actual work lined up for this company in the United States. So, for example, maybe you will get a third-party letter of intent from a prospective client who is interested in hiring your company to provide services. So, a contract can be included as evidence that shows that the new company that is formed is not just a paper company. So definitely there are some evidentiary considerations you want to be careful for, but generally speaking, yes, it is possible for an entrepreneur to use their own U.S. company to serve as the O-1 petitioner. Now, the EB-1A and NIW are both green card categories that allow the applicant to self-petition. So there is no requirement to have a U.S., petitioner, no U.S. agent required. The foreign national himself or herself can be the one driving forward the petition. So that can be an advantage for some people, especially if they are applying from abroad. Family considerations is also an important question. So for the O-1 visa category, the principal's spouse and children under 21 can join the principal and come to the U.S. on O-3 dependent visas. And it is possible for the spouse and children to attend school, but unfortunately, work authorization is not available for the spouse. By contrast, the EB-1A and NIW are both green card options, and the spouse and children under 21 can also apply for green cards as dependent beneficiaries. So everyone can get a green card if you were approved. And it is also possible for everyone to apply for work and travel authorization if you are choosing the I-485 option to adjust status in the United States. The EAD and advanced parole benefits are also what you can benefit for. Each applicant will have access to those benefits. All right. So now let's talk a little bit more about the strategic considerations, especially when you are trying to move from a non-immigrant visa to a green card. We spoke a little bit about this in the previous slides, but particularly, uh, you need to be mindful of the higher qualification that is required for the EB-1A, for example, as opposed to an O-1A or an O-1B. For example, if you qualified for an O-1B, it only requires distinction in the field. Uh, Going from that to the EB-1A can be a big leap because the standard for the EB-1A is to show that you have sustained national or international acclaim. So definitely the operative language for the qualification standard is different. Definitely speak to your attorney so that we can do a more deeper dive into how you qualify for the O1 and what you would need to do to strengthen the profile to get a more comfortable EB1 application. Timing is also an important issue to consider. So definitely consider how much time is left on your current underlying visa, because some visas are harder to extend or can be subject to more scrutiny once an I-140 or green card petition is filed. So for example, if you are on a TN visa and if your TN visa is expiring soon, maybe it makes sense for you to extend the TN visa first, renew the TN visa, so such that you have another 3 years to work with. And within those 3 years, you can go forward with the I-140 green card process. So definitely speak to your attorney to optimize the timing of these petitions such that you can avoid any difficulties with renewal of such visas. Certain types of visas are not affected by this. So dual intent visas, including the H-1B or L visas, it is okay if you have a green card petition that's ongoing. It should not be affected with regards to your ability to apply for or renew such visas. For O-1 visas, also usually okay. It is understood as a quasi dual intent visa, but definitely speak to an attorney to really get a precise understanding of the risks involved. Um, the last thing to talk about is family considerations. So, EB-1A and EB-2 NIW, as I mentioned, are both employment-based green cards that allows spouses and children to obtain green cards also um, as derivative beneficiaries. Definitely, if you have children who may be aging out soon, consider filing for the I-140 early enough to avoid issues with the child aging out at 21 and not being able to benefit from those benefits. All right, so the last question we will go over before going over to the Q&A is the question, are extraordinary ability categories available for entrepreneurs? And the answer to this question is a resounding yes. EB-1A and NIW both allow for self-petitions, meaning that both green card pathways are possible options for entrepreneurs. Changes in the EB-2 NIW standard under matter of Janizar made NIW a much more friendlier and possible category for entrepreneurs. And now there have been policy announcements that have narrowed the adjudicatory standards down a little bit. So definitely not to say that all entrepreneurs will be eligible for an NIW, but there are some strategies that you can use to prove a, broad prospective impact to meet national importance. Really, there is some specific know-how that you would want to discuss with an experienced attorney on exactly how optimally you would frame your endeavor to go beyond benefiting just your immediate business or your immediate clients, but have a broader impact to the field or to the nation or society as a whole. But definitely, yes, it still remains that NIW is a very attractive and viable option for many entrepreneurs. The other thing to note is that it is possible to apply for an O-1A visa as an entrepreneur if you meet the eligibility criteria that we've discussed in the previous slides. Just that the requirement is that there must be a separate petitioner, which is a U.S. employer or a U.S. agent. As such, you should have a separate U.S. entity that will act as the petitioner. It is okay if you have ownership in the petitioning entity. There are, some special evidentiary standards, evidentiary considerations you want to think about. But generally, yes, it is possible to proceed that way as well. Okay, so we have reached the end of the presentation. I don't think there are any questions that came in. Maybe give a couple more uh, seconds to see if anyone else has any questions. All right, so I don't think there are any questions coming in at this point. Again, if you would like to discuss your case in further detail, please feel free to reach out to us for a consultation. We would love to connect with you. And yeah, thank you so much for your participation today. Thank you, Kelly, for sharing your expertise, and we'll see you at the next webinar.
Thank you.